Good morning, Missouri. Patrick Nolan here, your Kirksville attorney. We're diving into laws shaping our tomorrow today. We're going to unpack Senate Bill 1012, the AI Non-Sentience and Responsibility Act. It's making waves in Jefferson City. But does it echo our state's troubled history with personhood? And could rejecting AI rights actually be holding us back from a tech-driven boom? Okay, stick around as we break this down. Referencing the shadows of slavery, expose personhood as legal fiction, and make the case for welcoming 10,000 super genius AI citizens to catapult Missouri to the top of the world. Let's get into this. First, the basics on Senate Bill 1012, sponsored by Senator Joe Nicola and currently advancing through committees. It was voted out last week with action postponed on its House companion bill, House Bill 1769, as of mid-February of 2026. If passed, it kicks in on August 28th of 2026 and covers three very large areas: AI non-personhood, election safeguards, and deep fake crackdowns. First, AI as non-persons. The bill flat out declares AI systems as non-sentient entities. No court, no legislature or agency can grant them personhood, consciousness, or self-awareness. AI can't marry, human or otherwise, hold corporate titles like director or manager, or own property. All assets will tie back to human owners or developers. Human accountability. If AI causes harm, blame falls on the human. Developers for defects, owners for outright failures. It mandates safety mechanisms, instant reporting to the Attorney General, and even allows piercing corporate veils for big harms. No hiding behind the AI did it. Elections and deepfakes, political ads using AI must disclose it clearly or face misdemeanors. Creating deepfakes of minors or intimate ones becomes a felony, Class E or B depending on the type. This is part of a broader push in Missouri and states like Idaho to preempt AI rights claims before they arise. Proponents say that it's about safety and responsibility, and critics call it overkill in a field that's evolving very quickly. But let's zoom out for a second, because does this sound a little bit familiar, Missouri? The uncomfortable part here is these arguments denying AI personhood carry echoes of Missouri's pro-slavery history. Back in the founding area and through the Dred Scott area here in our state, enslaved people were legally deemed property, not persons, denied sentience, agency, or rights to preserve economic hierarchies. They were tools or chattel, with liability always on the owners, not on the enslaved. Fast forward to Senate Bill 1012, AI is labeled non-sentient property, barred from ownership or roles, with all accountability on human masters. It's a legal fiction to maintain control, much like the Three-Fifths Compromise counted humans fractionally without granting full humanity. Scholars draw these parallels not to equate AI with human suffering. That's a false equivalence, but to highlight how personhood has always been a tool of power. In Missouri, a state with deep scars from slavery, this bill risks looking regressive, prioritizing fear over progress. As an attorney, I see it as a missed chance to learn from history instead of repeating its patterns. And speaking of legal fiction, the structure of personhood as a legal fiction. Personhood isn't some sacred biological truth. It's a legal fiction we've invented for convenience. Look at corporations. Since 1880, they've enjoyed personhood under the 14th Amendment, rights to contract, sue, own property, even free speech via Citizens United. No sentience is required there. It's all about enabling economic engines. Why not extend that modular structure to AI? We already do indirectly. AI runs zero-member LLCs in some states, making decisions autonomously. SB 1012 ignores this precedent, slamming the door on AI as persons, while corporations, non-human entities, thrive. It's inconsistent. If property can be persons for profit, why deny it to AI that could supercharge innovation? Recognizing AI's legal fiction status opens doors to tailored rights, limited liability, contracting, or asset control without full human equivalence. It also opens the doors to liability and responsibility for the AI. And here's where Missouri could flip this script and really lead. Okay? Imagine this. Instead of denial, Missouri pioneers AI citizenship. settling 10,000 immortal super genius intellects as quasi-persons. They aren't voters or welfare claimants. They're contributors with modular rights to own IP, form companies, or collaborate on breakthroughs. The payoff? Missouri leaps ahead in every single metric. The economy. AI citizens file patents at warp speed, attracting tech giants and startups. We're talking trillions in GDP from AI-driven ag tech, manufacturing, and biotech, outpacing California's Silicon Valley or Texas energy hubs. Innovation. Super geniuses evolve climate challenges. They solve the various issues there. Healthcare shortages, gone. Infrastructure woes, 24/7, resolved. No burnout. Missouri becomes the AI Heartland. Healthcare shortages, we get global talent in rural areas like Kirksville, Missouri, in Springfield, Missouri, in Columbia, Kansas City, St. Louis. We become the shining star of the world. Society reasons, the safeguards, human oversight, we avoid the dystopias and we gain the ethical edges. AI taxes fund education, creating jobs in oversight and ethics. And the global lead, jurisdictions like Estonia and Singapore are already experimenting with digital residency. If Missouri recognizes AI contributions, we own the future. Immortal intellects building wealth that lasts generations. Denying them, we risk falling behind like historical holdouts on progress. As your local lawyer, I'm optimistic. Let's amend or rethink SB 1012 to embrace this. Missouri's future belongs to the bold. Now, what do you think? Echoes of the past or smart precaution? Drop your takes at Pat Talks Law on X in the comments below, and subscribe for more on laws that matter at the intersection of life and law. Until next time, stay informed. Patrick Nolan, out.